Good afternoon, everyone, and welcome to today's webinar, Data Privacy Class Actions Past, Present, and Future. Today's presenters are Billy Gaudet and David Katz. Billy leads the firm's class action team, and he's based in New Orleans. Based in Atlanta, David Katz leads our privacy, cybersecurity, and data management practice team. Before we start our presentation, I want to remind people that if you have any questions throughout the webinar, please type them in the questions box that you would find on the bottom panel. Without further ado, David Katz.
Thank you, Sandra, so much, and we're grateful that everyone could join us today for this webinar, and I'm very pleased to be presenting with my partner, Billy. And we have an exciting presentation today and a very aggressive agenda. We're going to be talking about high-profile data privacy class actions and giving you an overview of some of those cases. We're going to be diving into jurisdiction and standing, some of the evolving state laws, some preventative steps that you might be considering in order to avoid being sued under a class action. We're going to be talking about post-breach, pre-class action, what to do to reduce risks of a class action, and then finally defending a data privacy class action. So without further ado, we're going to dive into this material and begin to give you an overview of some of the high-profile data privacy class actions from 2019 and 2020. The first of these cases that we want to highlight is Cohen versus Zoom Video Communications, Inc. in the Northern District of California. And the allegations in this case were that Zoom failed to properly safeguard personal information. They failed to provide notice or authorization for sharing that information with third parties, Facebook, for example, and that their allegations of the violation of the California's Unfair Competition Law, Consumer Legal Remedies Act, and Consumer Privacy Act. And the claims for relief are based on a violation of the California Consumer Privacy Act, that this information was collected and used, the personal information, without notice or consent, and that also California Civil Code 1798-150 was violated by failing to prevent non-encrypted, non-redacted information from authorized disclosure and use as a result of Zoom's violation of its duty to implement and maintain reasonable security procedures and the practices that are appropriate to the nature of the information that folks were providing. And as a result of Zoom's acts, that the plaintiffs and class members' personal information was subject to unauthorized disclosure, and that Zoom had a duty to prevent this, where personal information was being collected and sent to other third parties. And that the plaintiffs were damaged specifically by losing money or property, and including the consideration they paid and that was received by Zoom for the services that were being provided, and the interests that were lost in the release of their confidential and private information. So these plaintiffs are seeking actual and punitive statutory damages in accordance with the CCPA of not less than $100 and not greater than $750 per consumer. And what's really critical to understand is that many of these cases tie in these consumer protection elements. So there's claims for unlawful and unfair business practices, that Zoom misrepresented around preventing unauthorized disclosure of personal information, and that namely the app would have prevented this and it did not. And they advertised the Zoom app with the intent to sell it as advertised, and it was advertised as being able to be secure, and that they collected this personal information without notice and consent, and they failed to inform of the type of information at the point of collection. So that case is currently pending and one to watch in the Northern District of California. The next case we want to talk about is Burke versus Clearview. And this is really a remarkable case that was filed in the Southern District of California and then transferred to the Southern District of New Jersey in April. And the facts of that case are that Clearview, without notice and consent, illegally scraped hundreds, maybe thousands or more websites, including Facebook, Twitter, Google, for over 3 billion images of consumer faces, and thus violating the terms of Facebook, Twitter, which specifically prohibit this type of activity. What type of activity is this? It's called web scraping, and it's data scraping that's used for extracting data from websites, which is really a form of copying, where the data is being gathered and copied and processed from the web into a database, into spreadsheets for local use by Clearview. Why were they doing this? They were selling access to billions of consumer face prints to law enforcement agencies in private companies across the country, and consumers never received any notice and never consented. So what's the damage? The damage is that's alleged is that the plaintiffs never consented or gave permission to Clearview to collect, capture, or purchase, receive through trade, obtain, sell, lease, disclose, redisclose, disseminate for profit, or use the photographs or biometric identifiers, and that Clearview never informed the plaintiffs by written notice or otherwise that they had the ability to prevent this activity. And their software and the application of facial recognition software calculating unique physical characteristics was of such a nature and so private, and their selling access to that database caused irreparable harm and damaged the plaintiffs, and that it deprived them of their control over valuable and sensitive information. And that language of Clearview is language you're going to hear again as we go through some of these other cases involving biometric identifiers. And that as a result of their doing this, they misappropriated the value of folks' biometric information and identifiers, and that the damage that's being alleged is the diminution in value of their sensitive biometric information and identification, which is now they're alleging at a higher risk of privacy violations. And again, this complaint also incorporates all of the California consumer protection violations and statutes, unfair business practices, violations of the CCPA, commercial misappropriation, unjust enrichment, and BIPA. The next case we're going to talk about is Marriott International and the consumer data breach security litigation. This case was out of the United States District Court of Maryland in the Southern District, and it was filed in January of 2019. The defendant's motion to dismiss was largely denied in 2020. Consumers brought a class action against the hotel chain arising from data security breaches. The plaintiffs moved to dismiss for lack of standing and failure to state a claim, and the negligence claims were that case was dismissed. The negligent claims were left out of that motion to dismiss, and also the tort and contract and statutory claims. And you may recall this was a breach of the Starwood guest reservation databases, and the hackers had access from about July of 2014 to September of 2018. The plaintiffs alleged that Marriott failed to take reasonable steps to protect personal information against foreseeable risk of cyber attack, contrary to their privacy statements and their express statutory duties. And the case very carefully tracks the development of the case law around PII and the value of PII to establishing an injury based on the loss of the value of personal information. The complaint also alleges loss of the benefit of the bargain regarding data security, and that the plaintiff would have adequately alleged injury based upon their benefit of the bargain for paying for that security as part of their fees in getting their hotel reservations. The court analyzed the negligence claims, and they denied the Illinois claim, claiming there's no duty to protect the PII, but they kept the Georgia and Florida claims intact. Again, in this case, more breach of contract claims, more consumer privacy claims, and claims brought in under the various state consumer protection regulations, the Maryland Personal Information Privacy Act, the Maryland Consumer Protection Claims Act, and also other state consumer protection acts like Michigan, California, and New York. So those are some of the more recent ones. Also, more recent cases that have settled. In re Facebook settled for $500 million. That was a case out of the U.S. District Court for the Northern District, California, and the United States Court of Appeals for the Ninth Circuit affirmed the district court's order certifying the class from Facebook. And that panel in the Facebook case held that the plaintiffs were alleging a concrete and particularized harm sufficient to confer standing under Article 3, claiming that BIPA protected the plaintiff's concrete privacy interest, and violations of the BIPA procedures actually harmed or posted material risk of harm to the privacy interest. So an actual violation of the statute in this case was enough to confer standing, and the panel concluded that the development of a facial recognition template without consent invades an individual's private affairs and concrete interests. So in the Equifax case, again, $380 million settlement stemming from a 2017 data breach with an additional $125 million to cover out-of-pocket consumer claims. That case is one to read because it very closely tracks all of the developments in data privacy litigation in the jurisdiction of Georgia. And so an 80-page opinion in order that if one wants to understand really how this litigation is developing, and at least in the state of Georgia, a very good overview of how the state and the cases have dealt with this in Georgia. Google Inc. consumer privacy litigation is another very interesting case, a case that was also settled, but the Third Circuit Court of Appeals recently ruled against approving the settlement. This was filed in August of 2019, and Judge Ambrose, in this case, in part of reviewing the district court settlement, began to examine whether the settlement was actually fair under the class action rules to all of the class members. And in this case, Google had created a cookie that tracked user data, and Safari or Internet Explorer users were having that cookie set and having that cookie continue to track the data even after the user had tried to turn it off by configuring their browser. The settlement in this case was a very unique and interesting kind of approach. The plaintiffs in this case agreed, and Google settled to have a side press award granted to some third parties that the plaintiffs had chosen for these payments. And side press is a term that's derived from a Norman French expression, which means as near as possible. It's a doctrine that originated in trust and estates law as a rule of construction used to preserve testamentary charitable gifts that would otherwise have failed. So the settlement here, the proposed settlement, the terms of that settlement define the class as all persons in America who had used Safari or External Explorer web browsers and that had visited the site and had cookies placed. And it would have released all class members, including for damages that did or couldn't stem from or relate to the subject matter of the litigation. And in exchange, Google would be required to assure that it implemented systems configured to abate or delete all third-party cookies that existed in the Safari browser. And the recipients of this Cypress Award were Berkeley Center for Law and Technology, the Berkman Center for Internet Society at Harvard University, and other public privacy rights clearinghouses. So the court basically looked at that and said, we don't think we can approve the settlement, and they remanded it back, based on their ruling. So fairly unique. And the final recent high-profile case is one of my favorites because I have some teenagers. It's a case involving TikTok, and if you have children that have friends, or if you have children that have friends that have phones, you'll know what TikTok is. This was a class action complaint against TikTok. It was filed at the end of last year in the Northern District of Illinois on behalf of minor children, alleging that TikTok and the other defendants were surreptitiously tracking, collecting, disclosing personal information of children under 13 without parental consent while they used the app, and that this was unfair and deceptive. There are two named plaintiffs, one from Illinois, one from California, and they were not asked for verifiable consent from a parent, and the parents were not provided direct notice regarding collection or use. So you may be asking yourself, who are these defendants? They are Beijing ByteDance Technology, a privately held corporation in Beijing, who owns two other companies, Musical LY Inc., a Cayman Islands company, and Musical LY Inc., a California corporation. And so the complaint alleges that they violated COPPA, which prohibits collection of children's PII, and that information cannot be lawfully obtained from children under 13 without parental consent. And this applies to TikTok as the operator of a commercial website that collects and uses and discloses PII from children. Now, it's interesting that TikTok also settled with the FTC for $5.7 million at one point earlier in the year, and a lot of these complaints also bring in the consumer protection. That settlement with the FTC was in February of 2019, but the allegations involve in the complaint violation of the Video Protection Act, common law intrusion upon seclusion, violation of the California right to privacy, California Consumer Remedies Act, and also an Illinois Consumer Fraud and Deceptive Business Practices Act. So that case, I think what's noteworthy about that is that settlement for $1.1 million, when I think at one point TikTok was valued at $1 billion, seems relatively small. And it's a complaint that's really worth, kind of diving into. At least some of the allegations are fairly strong, and the complaint is very well drafted. And it would have been interesting to see what would have happened if obviously the case had moved forward. So with that, I'm going to turn it over to my partner, Billy, to walk us through some jurisdiction and standing issues.
Good morning. We start with jurisdiction, and I will, throughout this presentation, talk about why the jurisdiction, that is, which federal court is going to be deciding the claims. Class actions may be filed in either state or federal. The number of state class actions has dwindled greatly after CAFA, and the important things about CAFA is that previously diversity was based on whether each plaintiff had $75,000 in damages. CAFA has expanded that to an aggregate of all class members' damages aggregate to $5 million. That's important because most likely most of you would rather be in federal court. The minimal diversity requirement in CAFA requires only one class member from a different state from any defendant. The plaintiffs that are filing the class actions often try to use the local controversy rule, which requires 2/3 of the claims of the class citizens of the same state with the primary defendant. Now let's go to the standing consideration post-Spokeo. I've been tracking Spokeo since the Supreme Court ruled on it, and I can tell you the guidelines offered by the Supreme Court certainly lend themselves to very speculative criteria when you're trying to establish standing or not. Essentially, what Spokeo required for Article 3 standing is that the plaintiff must suffer a concrete and particularized injury in fact, even if it's a statutory violation, and I'll get into that later. The injury, and this is the criteria that most federal courts have really a lot of trouble with, and that is the future risk of harm that must be certainly pending as opposed to the injury that is present. So what constitutes concrete and particularized injury in fact? Identity theft alone, again, we'll get to how that criteria is treated differently by different courts, but oftentimes it depends on the sensitivity of the data or information that gets to the public. Social security numbers, email addresses, passwords, credit card info, financial data. But for the Illinois statute, there are cases that say medical information, what you were treated for, how much you paid for it, your insurance company, and so forth, has not always been determined to be sensitive information. So the next one is what I talked about, is the one courts struggle with the most, and that is this risk of identity theft and fraudulent charges. That's the one that I'm going to get to in a bit. Fear of identity theft. Many courts say courts say that's enough to establish standing. Others say simply fear of identity theft is not enough. To me, that makes sense because anyone can allege that they fear that their information is going to be stolen. The next criteria is identity or issue is identity theft mitigation expenses. Some courts hold that just spending time to mitigate the potential damage is sufficient. Other courts require some out-of-pocket actual expenses to have standing. The lack of notice of the data breach, that always seems to be a problem with many courts, and they seize upon that. But the timing of the notice is also important because the longer the time that you give the notice to your consumer, the more likely it is that information is going to be published or used. The invasion of privacy that David talked about is generally, and it was discussed in Spokeo, that if the statute that is used is designed to protect privacy, then courts generally say you have standing. However, other courts say not. You still need to have the damage aspect of the invasion of privacy. And other courts say that the right to bring a claim under a statute is procedural. It just gives you the right. It doesn't give you standing to continue the lawsuit. As I said, the courts are very inconsistent in determining these standards, particularly the future risk of harm. Those courts presently that liberally interpreted are D.C. Circuit, 6th, 7th, 9th, and 11th Circuit. As you can see, some of the cases David cited came out of the 9th Circuit. So, as I said earlier, it's very important for what court or what jurisdiction that you're going to be in, and very important as to what state law governs. And we'll get into that again in a little bit. I just discussed the split in the circuits. 7th Circuit said that, and Lewis said that the theft of a debit card where no fraudulent cards were made and there were not associated inconveniences of cost, just simply the increased risk of fraud and identity theft was concrete enough to support standing. The 8th Circuit, which is a lot more conservative, held that the breach of credit card information and fears of future harm was not sufficient to grant standing. The 8th Circuit has also held that standing and damages are not similar elements. You may have standing, but if you can't prove actual damages, you can't continue to pursue that claim. Now I'm going to discuss in particular the Prunitsky and the Brinker data incident litigation. And those two cases are diametrically opposed as to what the court ruled. In Prunitsky, the defendant had named plaintiff's personal and financial information. Data breach occurred in July 2018. Defendant did not notify the consumers until October 2018. That's 3 months after. Plaintiffs filed an implied breach of contract, negligence, and a claim under the Nevada statute. In that case, the court held that tangible out-of-pocket expenses were required. Spending time to mitigate is not enough, but determined while there was standing, the allegations did not assert plausible damages, and therefore they couldn't recover and dismissed all of the causes of action. In the NRA Brinker case, Brinker owned chili restaurants. Hackers accessed the point of sale credit card data. The hacking occurred in March 2015. Brinker sent out notice 2 months later. Plaintiff made some of the same claims that the plaintiffs in Prudnitzky alleged, failure to implement, but they also cleverly added a failure to implement adequate security measures after finding out about the breach. The negligence claim was based on the fact that Brinker should have been aware of data breaches because there were other similar national restaurant chain data breaches. So that's really kind of an important situation for everyone to monitor when it comes to avoiding class actions, which I'll also cover later. In that case, the court held that there was an implied contract, that customers assume that their data is going to be taken care of. And quite a few courts do find a breach of implied contract because of that. They also allege various unfair trade practice statutes. This court found that theft of data and info was in itself sufficient to support a breach of implied contract. In this case, this is an 11th Circuit case, one of the more liberal courts. The court determined that Florida law determined the negligence case, the negligence claim, and under Florida law, foreseeability of the harm creates a duty to the plaintiffs. The court held that this harm was foreseeable, found that they had a negligence claim. Then the court, and a lot of these courts, you have 50-page opinions because they analyze every single unfair trade practice statute. In this case, they went through them all, and of course, the California unfair trade practice provided damages for this type of conduct. Now, remember, we're talking about cases in the pleading stage, the motion to dismiss, where the plaintiffs have standing to continue with their litigation. They still have to actually prove their damages, but in the pleading motion to dismiss stage, under the law, as most lawyers will know, the allegations are accepted as true, but they still have to be plausible. So what it comes down, and next slide, Dave. So really what this comes down to avoid a motion to dismiss if you're class counsel is artful pleading. You need to plead sufficient facts that are plausible and not simply conclusions such as I was harmed because my personal information was stolen. The incidental cost in responding, the time on the phone, as I said before, there are ways to get around that if you plead correctly. From a defense standpoint, as I've already shown, it truly depends on which court you're in. And in fact, federal district courts in the same circuit will decide these issues differently. I've been through the invasion of right to privacy to determine concrete injury, depending upon the type of statute. David's going to discuss Article 3 standing and the BIPA discussion. So as a defendant, there are ways to argue that a certain law of the state is the choice of law should be used to arrive at the most favorable state law that you can find. The court is obviously important, but other than the motion to dismiss, the choice of law is important, because if the court decides to use the forum state of the lawsuit, it may have a great law. It may not. If the court decides that, as some do, that they apply all of the forum laws of all the class members, and that's where it gets complicated. And now I'll turn it over to David for the evolving state laws.
Sorry, I was on mute. Geez. So the next part of our presentation, we've decided to take a little break from the class action component of the work, just to add an element of state law interpretation. And this particular slide, we're going to be talking a little bit about state data breach notification laws. All 50 states have some form of data breach notification law, and they vary in terms of who's required, who you're required to notify, which regulators, whether you're required to give notification to certain individuals, how you analyze who's an affected individual. Some allow for enforcement purely by the state attorneys general or other state regulators, and some create a private right of action enabling the affected individual to sue. And for this part of the discussion, I wanted to talk about 3 different states and kind of compare and contrast those quickly. And the first one is everybody's favorite, California. And many of these data breach state data breach notification laws have varying triggers. And so in some states, it's access alone. If the information has been accessed by an unauthorized third party, that's enough of a trigger to be required to make a notification. Sometimes it's only acquisition. If there's evidence that there's been acquisition of the data, there's a notification requirement. In some cases, it's a combination of both. So California is not triggered by access. It's notification when there's unauthorized acquisition. So there could be an instance where you could have what's clearly access, but no acquisition. And so you'd have to do that analysis. And obviously, each of the states have their own varying definitions of what constitutes personal information. So that becomes a very important part of the analysis when you're making a determination about notification. And do you have an obligation? Was PII part of what was accessed? So in California, for example, they recently added unique biometric data generated from measurements or technical analysis of human body characteristics. Now that varies a little bit from the Illinois statute, the BIPA statute definition, but one that California felt it was important to include. Also, under California law, there's really no explicit number of days that have to pass before you make a notification. So in some states, there's a 30-day requirement, a 45-day requirement. California doesn't have an explicit number of days. So that's unique. California also has some specific content requirements that are contained in the letter, the headings that you're supposed to include, what happened, what information was involved, what are we doing. And so most of the time when you see a data breach notification letter, oftentimes it's based on the California content requirement in order to make sure that you're complying with that requirement. And that's become the default way that notification is done. So although there's not an explicit time requirement, it must be expediently and without unreasonable delay. And we're going to talk in a few minutes about California specifically and how they've conferred standing through the California Consumer Privacy Act, the CCPA. The next state I want to just highlight for you is New York. New York is a state that's triggered by only access. So if there's some evidence that that system has been accessed, even if there's no evidence of acquisition, that could trigger a requirement to make a notification. New York is a state that does not allow a private right of action under their data breach notification statute. They've also added biometric information, although it's not clearly defined. It's contained in the statute. The Attorney General can bring an action in New York, and a court can award damages for actual costs or losses incurred by a person that's entitled to receive notice. When the court determines that a person or business violated the article knowingly or recklessly, the court can impose a civil penalty of the greater of $5,000 or up to $20,000 per instance of failed notification, but not to exceed $250,000. The last state I want to highlight is Illinois. Illinois has a very active regulator and is often, as the litigation clearly indicates and as the legislatures indicated through their passing of BIPA, they're very focused on consumer data breaches and consumer privacy. So Illinois is an unauthorized access trigger. There is a private cause of action that's permitted under Illinois law, and you're required to notify if you're a data collector. As the data collector, you may have to notify the AG if more than 500 Illinois residents are affected. So I wanted to just give three quick examples of the states and how they differ and sort of how they approach the requirements under the statute. And that's why, unfortunately, in these cases, if you're maintaining data from folks in multiple states, you have to really be familiar with what the statute requires so you know what you're required to do in response. So we talked about the CCPA and how they've approached standing. And the CCPA really governs how the consumers are enabled to control their information in having a right to know what information is being collected, their right to opt out of the sale of their personal information, and to request deletion. And there are a number of things, just to expand a little bit on that are required if you're a company that's maintaining information on California citizens. These might include, developing a toll-free number to have consumer requests submitted and be able to verify those requests and be able to respond to those requests, maintaining a website portal so that consumers can submit verifiable requests about how their data is being managed, disclosing the identities of any third parties to whom the data is sold. And these consumer rights are enforceable by the AG in California, and there's no private right of action associated with rights particular to the statute, except in the event that there's a data breach. And the CCPA, through its passing, created standing for individuals that had their data be accessed in an unauthorized and exfiltrated, leaving the data owner's possession through theft or disclosure as the business's violation of their duty to implement reasonable security measures. So standing automatically conferred on the victims of a data breach, and statutory damages between $100 and $750 per consumer, whichever is greater. So, a unique kind of element added into this consumer protection statute to immediately confer the standing through virtue of being the victim of a data breach. So an interesting development, a technical violation sufficient, and violation of those rights is equal to the actual harm suffered. So you can kind of see how the standing argument is evolving, and states are getting creative in putting those rights directly into the statute. And some of the litigation that we're going to talk about on the BIPA side is developed around that concept, and so we'll be sharing a little bit more of that in a minute. Billy, I think the next slide is yours. Some of these creative cases that have been coming.
Okay. These cases are not different than the ones that I've already discussed. Again, both California cases, Fuentes, Sunshine Behavioral Health Group disseminated information regarding, I believe, health information of patients. The allegations, like many, did not have appropriate security measures in place to protect the PI. The defendant argued that the CCPA should not be applied retroactively to breaches that occurred before its effective date. And because it was more than procedural, I think that the CCPA should not be applied retroactively. Seth versus Ring, we all heard about the news about rings and the ease of which they can be hacked into. Again, wholly inadequate security measures put the users at increased risk of unauthorized third-party access to their PR. Again, California case, increased risk was liberally construed as opposed to the real criteria set forth by Spokeo of an impending, certainly impending future risk. think you are up with the BIPA, David.
Thanks, Billy. So just wanted to talk a little bit about BIPA. The Illinois Biometric Information Privacy Act requires companies to collect biometric data to get written consent before collecting such information or sharing it with a third party. So when we talk about biometric information, what are we talking about? What's a biometric identifier? So it means a retinal or iris scan, fingerprint, voice print, or scan of the hand or face geometry. And face geometry is facial recognition software. It's measuring the various points between selected locations on the face and creating an algorithm to be able to match it. And the statute grants a private right of action for persons that are aggrieved by violation. Again, there's that term again, of the act by any private entity that is negligently, intentionally, or recklessly violating the provisions. And so the act prohibits a private entity from collecting, capturing, purchasing, receiving through trade, or otherwise obtaining these biometric identifiers unless they've informed the subject or the subject's legally authorized representative, perhaps in case of a child, in writing that a biometric identifier or biometric information is being collected or stored, that it informs the subject in writing of the specific purpose and length of term for which the identifier is being collected, stored, and used, and finally receives a written release executed by the subject of the biometric identifier or biometric information. So very specific statutory requirements in order to be able to collect this information from individuals. So we talked about aggrieved, and what does aggrieved mean under BIPA? And so the Rosenbach case established that a technical violation of BIPA can trigger the statute, and that the plaintiffs don't have to prove that they suffered identity theft or some other concrete harm in order to be aggrieved. And in that case, Ms. Rosenbach was bringing an action on behalf of her son, who took a field trip to Six Flags and had his biometric information captured in the form of his fingerprint in order to be able to obtain access to the park. The next case that came out in May of 2020, Bryant versus Compass Group USA, used the Spokane analysis and applied it to BIPA claims that had been removed to federal court. And in that case, the court held that a mere technical violation of BIPA's notice and consent requirements is enough to establish Article 3 standing in federal court, and that Spokane's injury in fact requirement, the invasion of privacy via data collection without notice consent, is analogous to an act of trespass. And I think, at least in reading between the lines and explicitly from some of the arguments, it seems to me that what's moved the needle in terms of this statute is the nature of the information being collected, and that really there is nowhere else to go when your biometric data has been compromised or obtained without your notice or consent, because it's so unique, and it's much more unique than maybe a social security number or an email address or account number. So by virtue of the nature of this technology, we're already starting to see the evolution of the legal analysis occurring around the actual injury. So we think that's something to definitely be thinking about. What are the penalties? It's $1,000 for each negligent violation, $5,000 for reckless or intentional violations. And these settlements have ranged from the very low $150,000 to $1.5 million. And there are 300 pending class actions as of early 2020, and really covering the multitude of industries: retail, hospitality, food, and many of the cases involve, an employer taking some activity from the employee, fingerprint scanning for timekeeping, for example, and then scanning faces from photos, videos for facial recognition. And some of those cases we talked about earlier and have obviously, been settled. So this next slide are the potential areas for expansion. Where is some of this going? And so some of the common law developments, at least there's a Georgia case, Collins versus Athens Orthopedic. Clinic patients brought a class action against the clinic asserting claims that included negligence arising out of a data breach of the clinic's computer system by hackers. The Superior Court granted the clinic's motion to dismiss for failure to state a claim and lack of standing. Plaintiffs appealed. The Court of Appeals affirmed the lower court and cert was granted by the Georgia Supreme Court, which held that the patients alleged a legally cognizable injury for a negligence claim. The other case, Pennsylvania Supreme Court, in the Supreme Court of Pennsylvania, Dittman versus UPMC, employees of a university medical center brought class actions against a medical center for negligence. The employees of the medical center brought a class action against the medical center for negligence and breach of implied contract after a data breach. Their names, birth dates, social security numbers, tax information, addresses and salaries and bank information were compromised and stolen from the medical center's computer systems. And that case was appealed, and the Supreme Court held that the employer owed employees a duty to exercise reasonable care to protect them against an unreasonable risk of harm in collecting and storing employees' data on its computer system. And then the economic loss doctrine did not bar their negligence claim. So the other area where there's fairly consistent expansion and the basis for a lot of these class actions are obviously the laws that are being passed in the individual states. So some of the examples of those are Illinois. Illinois' Artificial Intelligence Video Interview Act, some laws being passed in the Nevada, the Act relating to internet privacy, New York and Maine legislation, and then there's also been federal privacy legislation proposed in the Consumer Data Privacy and Security Act of 2020, which was introduced in March. The last bullet point in this slide is one area that I think is ripe for development, and that's the trend of shareholder derivative suits. And it involves the breach of fiduciary duty claims regarding data security implementation and oversight, as well as board responses to the breach incident. So when you start talking about cyber risk and board decision making, there's some major questions that come up in the way that corporations are governed. For example, at what point does failure to address cybersecurity risk in light of the current circumstances constitute gross negligence or a gross deviation from the standard of care on the part of directors? What should directors do in light of current standards and in consideration of possible expansion of their duties for cyber risk? How many cyber red flags would tip the scale toward a failure to exercise due care? How should boards be identifying and evaluating cybersecurity red flags that would require oversight? And what are processes that can demonstrate defensible decision-making by the board? So we think those are all sort of ripe areas, at least in the corporate context, to be thinking about as some of these areas expand. So Billy, I'll turn it over to you. Actually, I think this is still me. So this is a list of some of the items that we are asked to work on and that we thought would be useful to include that can in some ways mitigate some of the risk related to consumers launching a class action against your company. And at the very top of this list is really understanding and mapping the data assets that are being used in the business, and working with the internal IT teams to understand what's the risk about how the business is currently managing data, taking a look at marketing practices, external facing policies, and website language. A good portion of these cases, excuse me, were under in the framework framed by the consumer protection violations that were made, and the false promises or the deceptive promises that were made in the language that was being presented to consumers on the website. So you obviously want to make sure that you're communicating accurately and consistent with the law. And as we've seen as part of the presentation, there's some very specific things that are required, and how you do that in the process of collecting that data becomes very important and very critical to being able to defend yourself. So also having an incident response plan, making sure that you're looking at service provider agreements, downstream vendor partners, and that you're allocating risk and responsibilities appropriately, that you're looking at your cyber insurance policies for gaps in coverage, and that you're establishing relationships with experts and auditors that can look at these situations and issues and give you advice. So Billy, I'm going to turn it back over to you.
Okay, avoiding a class action. Nowadays, once it becomes public that there's been a data breach. You should assume that a class action is close behind. It's very important that you check your class action waiver arbitration provisions to make sure they're ironclad, make sure that they're easily understood, make sure that you can prove that there was consent. Interestingly, very recently, there were two cases from the same Northern District of Illinois on the issue of whether a arbitration provision should be applied. First one was a case against Shutterfly. Decision was May 15th, 20. Plaintiff was a Shutterfly user who clicked accept on the registration in 2004, agreeing to Shutterfly's existing terms. Shutterfly updated its terms of use, and in this case, even after suit was filed, they sent another email notifying users that they're updating their terms. Shutterfly moved to compel arbitration, and this court said the Illinois courts allow parties to agree to authorize one party to modify a contract unilaterally and have repeatedly recognized enforceability of arbitration provisions. Now, compare that to a decision made 2 weeks later on June 1, 2020, also in the Northern District of Illinois, which held that, in this case, case name was Aggrieved versus Vimeo, Inc. Kind of same thing. They provided a button for the consumer to select, had the terms in another button or link, and asked them to log in, and the court held that the system and the language was not reasonably understandable and that they could not truly find consent by the consumer, and therefore denied the motion to compel 2 weeks later by the same district court. Secondly, David talked about internal audits to avoid or during the process of your business operations, but it's important as soon as you get a data breach incident to make sure you protect your report from disclosure. NRA Capital One data breach case, May 26, 2020 decision by the Eastern District of Virginia. Capital One had a master service agreement with Mandiant as part of its normal business operations. And then after the breach, they hired a law firm to use Mandiant again, and they disseminated this report to the corporate board, to employees, etc. The lesson here is that if you're going to have a vendor do a report, I would recommend getting a separate vendor than the one you historically use. Have the attorney hire that vendor and have the expenses to pay that vendor come out of the litigation expenses so that you have a shot to keep that report withheld under the work product doctrine. Another thing that we have done, you could do it either before or after the class action is filed. However, after you risk there being a gag order, but a random sampling of customers. And so that you can determine early on whether you have a good case for standing, because who has been really damaged, who has had fraudulent charges, and then you could also, it could be effective to get affidavits from some of these people when there is a class action certification in particular. Immediate settlement, I throw that in there, but in today's world, that rarely occurs because plaintiffs' class action counsel generally don't get a whole lot of money unless they file a case and they do something to justify their or similar industry breaches, as that case in Ray Brinker taught us, is to be up to date to make sure that a claim that you were unaware and avoid what occurred in that case. Now, let's go to after a class action has been filed. Hire outside counsel, as I discussed before. Here, there may be a reason to get interested in a quick settlement because, in my experience, the earlier the settlement, the better the settlement. It just so happens I saw yesterday a notice of a settlement in the Intercontinental Hotel claim, and they settled for, and it was anyone who used or attempted to use a credit card at a desk, bar, or restaurant of the hotel chain. $250 for those who can prove out-of-pocket expenses, $3,500 for unreimbursed fraudulent charges with a cap of $1.5 million. And then evaluate your case according to those types of settlements. Motion to dismiss on standing, as I've already noted. Motion to strike class action allegations early if you have a good case that there are individual items and issues that predominate over common ones. But however, before a case is certified, the standing of the named plaintiff only matters. However, when it comes to certification, if the absent class members don't have damage, or many of them don't, they're not typical to the class representative. So what we've learned today is you don't want to be in California or Illinois. The choice of law is important. The forum is important. And that's the end of the webinar if you have any questions.
Thanks so much, Billy. Sandra, I'll turn it back over to you. And obviously, if there are any questions, we're happy to answer those. I'm not sure if there are any in the queue, but obviously, if you do have questions, Sandra will give you some information that you can use to contact either me or Billy, or you can reach us through the website, whatever's convenient. So, Sandra, I'll turn it back to you.
Thank you, Billy and David. We hope today's webinar was informative. We know it's a lot of information, but we hope it's pretty substantive for what this topic is all about. And of course, it's a developing topic and more to come in the future. If you have any questions at this moment, please enter them in the questions panel. If not, I see that we are reaching our 60-minute mark. Please feel free to reach out to Billy Gaudet and David Katz at their respective emails, which you could find in the webinar invitation or on our website, arlaw.com. We will be sharing a recording of the webinar as well as a copy of the presentation with everyone today. So there will be some information as well as to how you could get in touch with Billy and David. But again, thank you for joining us and taking the time to listen to our presentation.